Go ahead, have a seat. And that would complete our presentation.
So this offense is called obstructing official business. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail and $750 fine. So that's the way the plea agreement was presented to the court. Those are the maximums defined by law. The other charges, whatever they were dismissed, so they're of no concern. With regard to the outcome, the probation department's been monitoring her behavior since 2018 and gives no negative reports. So that's a crystal ball in one respect, because the past often predicts the future, but it doesn't have to. So their recommendation informally, without a full report, is that she continue on supervision. So I'll set a 5-year term of adult probation supervision, 180 days jail, 173 suspended, 7 days credit. So no additional time now. You can, however, Ms. Newcomb, earn the additional 173 days if somehow you don't take this seriously and don't report or violate laws. So there's a long list of standard terms and conditions of supervision that the court's going to... Wait, let's go with I'm talking first and you don't. This is how the problems develop. All right? So you've been on supervision, but it doesn't count. The past doesn't count toward the future. That's pre-trial. The past does help me indicate I don't expect to see you again because the probation department seems to think you're not a problem. But I'm going to put you on supervision for 5 years and tell you that there's 173 days suspended in case you can't comply moving forward. I'm going to order the $750 fine plus the court costs, and then your ability to pay over time will affect whether it's actually collected. Because if I don't impose it today, I can't impose it later. Understand? The terms and conditions of probation will primarily involve your compliance with the law, reporting requirements, and then any education or training programs they think are necessary for you to be a good citizen, which in your case may not be a lot, but that's generally the purposes of supervision, is to help people become law-abiding people if they aren't already. So 173 days at risk, there's a $750 fine, plus the court costs that have to be paid, subject to ability to pay. Understand?
Can I ask you a question?
Sure.
Do I have to go to jail?
You want to answer that or should I?
I prefer you say, but I think no.
No, unless you act out.
Oh, okay.
173 days suspended.
Okay.
But it does demonstrate a good point. What I think I'm saying isn't what people are always hearing.
But there will be a fine. And
Yeah.
if I'm bad, I'll go to jail. But if I can stay good, I don't have to. But I do pay the fine.
Yeah, subject to your ability to pay.
Okay.
Like, the point's not to put you in poverty. The point is to modify your behavior. If you have $30 left at the end of the month, then that should go toward the fine or the costs. At the end of the 5 years, if you can't pay it, you don't get incarcerated for being poor. It's forgiven at that point in time, but it is meant to be a punishment. Does that help you?
Yeah, I think I understand now.
Okay. Keep doing what you have been doing with regard to probation compliance.
But I still call in if I have to leave the state or something.
Or show up, whatever they say, you step and fetch it.
Okay.
Corrections or clarifications, Mr. Gerlach?
Clarification, in the entry it says 90 days is the maximum.
I did say that wrong. It's 90 is the maximum. Yeah,
And you said 170.
I did. It's 83, not 90 is the maximum. I said 180. I bumped it up a letter, so 83. Thank you very much. My sentencing entry is actually back there on the desk right now, which doesn't help me here. Thank you for that.
Thank you, Your Honor.
So 97 credit, 83 suspended, $750 fine, plus costs.
Yes, Your Honor.
5 years probation. Thank you for that correction. My apologies.
No problem.
Thank you. Ms. Canepa? Okay, you can check out right now if you would, Ms. Newcomb. That doesn't mean you have to leave the courtroom, just means I need that chair.
Oh, okay.
Thank you, Mr. Gerlach.
Thank you very much.
We'll switch to Angela's case next. And we'll need another chair. You can help us. I think we will. I don't have it. You have co-counsel with you today, Mr. Burns? Are you by yourself?
Mark Hunt is not here today.
Oh, my apologies. Okay. So this is State of Ohio versus Angela Wagner, case 156. Mr. Crapence is here on behalf of the defendant. Mr. Hunt's not appearing, so we don't need the extra chair. And you had an opportunity to hear the victim's statement and the state's recommendation, right, Mr. Ferentz? Crapence, I'm sorry.
You're fine. I have, Your Honor. Thank you.
Okay. And you heard it also, right, Mrs. Wagner? You heard everything that was said before, right? Okay. I want to circle back on one thing, Mr. Crapence. Was there any part of the plea hearing that you thought was in error or deficient or you wanted repeated?
Your Honor, at this time, nothing comes to mind.
Okay.
But
Yeah, I wasn't here, but if there was an error, we can still fix it.
appreciate that.
Did you note anything that should be emphasized, Ms. Canepa? Any problems with the plea?
No.
Okay, thanks. So it's the defendant's opportunity to make a statement, so Mr. Crapence gets to go first, then Ms. Wagner, you get a chance, so go right ahead.
Your Honor, thank you. First, with respect to maybe some merger issues, I suggested in my sentencing memorandum that there are two sets of 2 counts each that we believe should be merged for purposes of sentencing. That was counts 16 and 18, as I recall, and I think 20 and 21. If I can read my writing here. And I won't repeat the arguments therein. I quoted the bill in particular with the specificity of what actually was charged, and it seems to me that they are similar imports as if they should be merged. I don't know that. I've not read a response to that, so I don't know the state's position on that. With regard to the sentence or the plea agreement and maybe the agreement on sentencing, Ms. Wagner is very cognizant of the fact this court's not bound by anything that happened before this court took over this case. In fact, Judge Sherry also was not mandated to follow a jointly recommended sentence. Now, he did review it. He did say he would agree with it, but that in no way binds you. And my client is very aware that this court has the authority and the responsibility for deciding independently what the appropriate sentence is. So we do not walk in this morning expecting that this court will just rubber stamp the things that have happened before. But for the following reasons, I think that the court should accept the jointly recommended resolution in this case. As this court knows, these are horrible events. I appreciate the families being here and making the statements that they did. They have shown a lot of patience and I think maybe courage and repeatedly showing up for every hearing. And I do appreciate that, and I know that their words do not fall on deaf ears. Your Honor, my client was involved with these actions. As far as her specific actions, she did not enter into any of these dwellings. She did not bring a gun personally. She did not pull a trigger. She did not directly cause the death of these folks. That said, she was aware of it. She took her own steps to try to assist in that plan. And that is something that she has taken responsibility for. In addition to taking responsibility, she has come into this court and she's testified against her son. And that was a task that was not very easy for her. It was important for her to do so, but it was also very important for the state. The state knew that the remaining cases after Jake had entered his plea were still not 100%, not an absolute win, because one person saying something sometimes without corroboration isn't enough to sway a jury to prove beyond a reasonable doubt. It's very important for them to have Ms. Wagner come in and testify and corroborate the testimony, the evidence, and the facts that Jake had testified to. Toward that end, after Jake had proffered, we never let Angela review the statement, the proffer, because we wanted to keep a clean wall between the two of them, such that she was not parroting back what somebody else had said. And I think it proved her value to the state as a witness. And it's because of those efforts that the state entered into this agreement, which I know the state probably didn't like, but felt it was necessary, and I think that they probably made the right call. Ms. Wagner has lived up to her end. She will continue to live up to her end of the deal, which again doesn't bind this court. I do want the court to know that she has provided me this morning with a list and some certifications of completion of some programs that she's taken while she's been incarcerated for a very lengthy time in Delaware County. And I count offhand, I'm not going to read them all, but I count probably 40 to 50 different programs that she has completed. She has found something of a niche, and she's been in one place so long. She's been, entrusted to act as a trustee, but also has taken it upon herself to mentor young women who come in to the jail, and then they come out, and they come back in, and she's told me many stories about the revolving door of women that she's met and been able to help. I believe that she, for the next more than almost 25 years of her life, will have a purpose. I know that she is the type of person who will listen, who will help to counsel, who will try to direct younger women into the right direction, a path that she hopes that they will take. She has done as much as she can possibly do to improve herself, her situation, and to give back. She has written a statement at the appropriate time. I would ask the court to allow her to read that as well. All that to say, Your Honor, I believe that the jointly recommended sentence is appropriate. I know that in the plea agreement, we had agreed to a specific sentence for each of these counts. However, as my addendum to the sentencing memorandum indicated, I don't think that we can follow that because of how the Supreme Court has interpreted the law with regard to firearms investigations. I did include, it was yesterday at some point, a suggestion of how to arrive at the same, if the court is inclined to, and do so in compliance with what I believe would be the appropriate legal framework. Thank you.
Thank you. Ms. Canepa, do you agree that 18 merges into 16 and 19 merges into 20?
Into 20?
Unauthorized use of property, that's the way it was suggested by Mr. Craypence.
Yes. I would agree that there could be an argument as to 16 and 18, but not the 19 and 20, Your Honor.
Want to argue that further, Mr. Craypence?
No, so nothing past the motion. Thank you.
Okay, thanks. So I looked at the bill of particulars and read the indictment. I don't have all the discovery when I read through the trial transcript. I can agree that 19 merges into 20 and 16 merges into 18 merges into 16. So I presume you would have the court sentence on the higher level felonies, Ms. Canepa?
Yes, please.
So 16 is a felony 3 and 20 is a felony 4, so there'll be no sentences imposed on 18 and 19. They merge into 16 and 20. That being said, it's your turn, Ms. Wagner, for your statement.
Thank you. You're here. I have to tell me if I'm close. I go?
Yeah.
Oh, thank you.
I've spent my whole life trying to be the opposite of everyone that I knew. Not too fluffy, not too wordless, not too strict, not too controlling, not divorced, not too ungrateful. The perfect daughter, wife, mother, grandmother, perfect person. Always striving for perfection, thinking that that was what was wanted of me. All of this had been stuck down so far that I didn't even know who that woman was. I didn't realize I was so weak and flawed and broken that it would lead me to make rash emotional decisions. That when such a tragic event would happen within my family, I just froze. I couldn't think. I'm not saying this for justification, Your Honor. This is why it shames me to say at that point in time, I didn't consider the consequences those actions would cause, or the depth of pain that they would bring upon the Romans or others. I know their pain must be unbearable, because separated from my family, the ones I love most in the world, brings me unbearable, suffocating pain too. And for this, I am so truly sorry. I can't undo what's happened. But the regret and the remorse that I feel is my daily reminder of who I once was and who I do not ever want to be again. Thankfully today, I'm not that woman. I've committed myself to change, to growth, spiritually, mentally, and emotionally, to letting God be my guidance. Each day I work on being a better me, rewiring my brokenness, living for a purpose so I can be filled with wisdom, knowing to slow down, to listen, and to ponder so I don't get carried away with any emotional decisions again. I'm not looking for perfection anymore. Now my desires and goals are for continuance of growth, for sharing the compassion and unconditional love to others that God shows me daily, and to remain this better me. God has opened my heart and my eyes. He has showed me what reality looks like. I've seen it in all the beautiful, unique women that I have met and been sharing housing units with. This world needs no more pain, so I give back any way I can, whether it is to show love, compassion, encouragement, a listening ear, a smile amidst their darkness, or just maybe by hearing my story. They will be enlightened of what real consequences made by emotional decisions looks like. My hopes and dreams are that I can make each day count for something good, to always move forward, not backward. Because all I am today, I have to give that glory to God. It's His love, His mercy, and His grace that has changed me. Thank you.
Go ahead and have a seat. So, Mr. Craypence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Canada Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Craypence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence, when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally, on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Cravens? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? Mr. Craypens?
No, Your Honor, my client has signed an affidavit of indigency on that approach.
Thank you. Yes, I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person who could have stopped the whole thing with one phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly, any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case, the Rahab case is cited in the decision. They go back to 2017 case. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to